Be seated.
Back on the record, folks, only about a call versus Mary Reed.
Good morning, Your Honor. Matthew Kelly, on the list today is scheduled for Wednesday.
Well, first is Evan Arujo. Allegation October 18th in the town of Barnstable. Found with a firearm, armed assault, attempted murder, assault and battery with a firearm, ammunition without an FID card, firing, discharging a firearm within 500 feet of the building. Not guilty of pleas have been entered today. Commonwealth person Jacob Winbush. Allegation October 18th in the town of Barnstable. Firearm, armed, assault, attempted murder, assault, battery with a firearm, possessing ammunition without an FID card, discharging a firearm within 500 feet of the building. Not guilty of pleas being entered on your behalf.
And gentlemen, you both understand that if you commit another crime, whether it's state or federal, I can hold you without bail for up to 90 days.
Yes, Your Honor.
And that would be 150 as to each charge.
Attorney Rogers is appointed Mr. Arujo. Attorney Garnett is appointed Mr. Winbush.
And Jesse, what's the Commonwealth's position on Mr. Winbush at this point?
Your Honor, the Commonwealth has filed a motion for 58A. I believe on both defendants, we're looking to go with next Monday for a hearing.
So you're asking for your 3 days, and Ellen, you're asking for the additional days on the defendant's point.
That's correct. The Commonwealth would be ready to go today.
Understood. Okay, so the defendant's asking for further time to get this covered.
That's correct.
So, okay, and you would agree with that date as well, Larry?
Yes, following Monday.
So, as Mr. Winbush's case, at this point, Chuck, it is next Monday, the 27th, for a dangerousness hearing.
Without bail,
So,
We're doing one thing at a time. So now, Ellen, what do you have to say? Anything else on behalf of Mr. Winbush?
Yes, Judge, I have two written motions for you, one for an investigator, the other one to preserve and produce evidence. I'd like those to be acted on. I'd also like to verbally challenge probable cause for the issuance of the complaints.
All right, so we need that. I need a motion.
I'd like it to be written.
I definitely do.
I would
Like the complaints issued from the clerk's office, the clerk found probable cause. It's a vehicle for that, a motion to dismiss based on probable cause that I need to have in writing with affidavits and served on the Commonwealth.
Okay. And if that's the case, I'd like that heard on that.
On
same-
Monday as well.
On that same day. Thank you.
All right, so on the motion for investigative funds, that's allowed. Jesse, is the Commonwealth taking a position on the motion to preserve any evidence?
as it relates to anything in the care and custody of the police, there's no objection. I understand that some surveillance video has been requested, whether or not they actually get anything is the question. And additionally, the search warrants would be speaking of the return.
Okay. So. All right, so as to the motion to preserve observed, there are at least 6 main ideas. It looks like body worn cameras for all the offices, all video surveillance from the interior, exterior, from 174 Main Street and 156 Main Street, audio and video bookings, and interviews, the search warrants, affidavits, and photos, and those are all law enforcement officers present. And then contact information for civilian witnesses. So we'll allow that as of today, as to any items that are in the custody and control of the Commonwealth.
Thank you.
So is that all with regards to your client at this point?
It is.
All right. So Jesse, what's the Commonwealth's position on Mr. Arraigned?
The Commonwealth has filed a 58A motion, and we've also filed a motion to revoke Mr. Ruger's bail on the juvenile youthful offender docket.
Okay, and so with regards to the 58A, again, the request to continue that to the 27th of October is allowed. And Flurry, what is your position on the Commonwealth's request for a revocation?
And I would ask that you deny the common request for revocation.
So you're not arguing that I can't do this at this point, right?
No, I'm not arguing, I'm not arguing that procedurally the Commonwealth can't ask for it, but I would suggest that a precondition to.
Well, certainly I'm going to listen to what, I haven't even heard their argument yet, but the way in which I look at the statute, this motion needs to be filed at the time in which Mr. Ruger is brought to court. And this is the time, it's not a matter where you have to continue. If the Commonwealth is seeking this.
The motion should be heard today. I
Okay,
agree with that.
so go ahead, please.
Thank you, Your Honor. Commonwealth asks that you revoke the defendant's bail on the juvenile docket 24 DL 0273FA and the YO docket 2572 YO 12. Basically, this being that the defendant has picked up a new case that he was just bringing on here. On the juvenile and youthful offender dockets, he's charged with assault with a dangerous weapon, and that stems from an incident when he was 17, and he was at the National High School for a football game. He followed another student out to the parking lot and had pulled a firearm from his hoodie and attempted to pistol whip this other juvenile, and that juvenile was able to block it with his arm. Police were called and the defendant fled the scene. Additionally, he was arraigned and released. He was then as a full offender and arraigned and was released on the condition to remain on home confinement with a GPS. So the Commonwealth would suggest there are no conditions of release, where now he has another case now in District Court that is 18, also involving a firearm. This time he was charging a firearm, and this occurred while he was on the house arrest with the GPS. So there are no conditions of release where he is still going to be able to commit these acts from his own residence. Commonwealth asks that you remove his bail.
All right.
Thank you, Your Honor. In order for the court to find, in order for a court to remove my client's bail, the court does have to find there's probable cause to believe that Mr. Joe committed no offense. And I suggest that based on the police report and the facts and circumstances listed in that narrative report, there is not probable cause to believe that Mr. Joe committed assault with intent to murder. Your Honor, quite frankly, the facts do raise probable cause to believe that Mr. Joe was in apartment K, but that's essentially it. There's no facts or information in the police report to suggest that the guns, the ammunition, or any of that were ever in apartment K. Paragraph 2, Your Honor, there is some unidentified witnesses reporting that the gunshots may have come from apartment K, but I suggest that's the unidentified witness that cannot establish probable cause, just akin to an anonymous tipster. When the police officers do get a search warrant and search apartment K, this is in paragraph 8 of the arraignment report, the police do recover 2 rounds of ammunition and 2 firearms, but the police report does not state where those firearms, where that ammunition was found. I note too that not any further, besides the 2 rounds of ammunition, there's not further ammunition recovered from this search warrant in that apartment. This 174 Main Street multi-residence unit judge, this report says there are witnesses all over the apartment. From the facts listed here, the firearm, the rounds could have come from any one of those unnamed witnesses.
I will state that in the end of paragraph 2, it does identify one witness who states that he heard multiple gunshots from the apartment bay.
See the application.
Because I would just say, it's not just probable cause to believe that an assault with intent to murder occurred, that my client was the one who in fact committed that crime. And aside from Mr. Rizzo being somewhere in the residence of 174 Main Street, there's just no facts in this arraignment report that give rise to believe he was the one holding the gun, or anywhere near the gun, in fact. With respect to his likelihood of causing a danger, community judge, the prior district court case here, 25-573, that case was dismissed. I would note that Mr. Rizzo was not arrested on the scene in that report, that the entire complaint was based on basically a grainy video and that no gun was ever recovered. As far as I'm aware, this is the first Elmo violation that my clients have in the time since he's been on that GPS monitor. He is a very young man, Judge, and we know that adolescent brain development does make it difficult for young people to think ahead. So I think this arrest, he understands that there are consequences, certainly going to be consequences in the juvenile court on violation of pretrial conditions, Judge. But I don't know that the Commonwealth has met their burden to show that no conditions are released would be sufficient given the lack of probable cause in that police report to link Mr. Rizzo to that fire and that gun. And then the rest of the history, Judge. So I suggest that conditions could be appropriate here, asking not revoke his bail.
Jesse, is there something given me, is there something that Mr. Rizzo was given the warning that bail is being revoked for about the
Yes.
X amount of days on the YO stuff?
Yes, was that not included in the last
I see the pretrial release conditions, which says obey all local, federal, and state laws. And I see a pretrial violation. You're hereby notified that the above defendant was alleged to violate the terms and conditions of the trial release. Lays out what happened. I would assume here, and plus it's violation of curfew.
Yes.
But certainly those are things that happen all downstairs in the juvenile court. And I have to, like I told them, if you would have committed some crime, whether it be state or federal, I can hold you without bail for up to 90 days. I don't see that in here.
I don't have access to the juvenile docket. I can ask the clerk's office to get a copy of it.
We're gonna need that, to make that finding. And I don't know if they even give that warning downstairs.
They do. I was present for that arraignment.
For the arraignment, the
For the
arraignment that you're talking about.
Colorado one and Falmouth, yes.
All right, so I'm gonna need to have that.
I can get that.
Whether by FTR or actual document.
I can get that.
All right, well, I'm gonna take that. I won't have enough at this point, so I'm gonna hold that till 2 on my decision. And certainly he's held until, plus I wanna read the application.
Yeah, I would object to the Commonwealth supplementing their motion by
I'm asking for it, so. 2 o'clock. All
advisement.